Our topics for today, I'm going to provide an overview of the existing EU product liability regime and the perceived issues with it, particularly in the context of emerging technologies like AI. And then I'm going to take a look at the Commission's proposals to revise the regime and consider what impact those changes would have. After that, I'm going to talk through the EU's proposals to introduce two new bespoke regimes specifically designed to tackle the perceived risks of AI technologies. And finally, I'm going to say a few words about the position in the UK, which after Brexit needs separate consideration as it is no longer legislatively aligned with the EU. So I want to take a look at some of the key proposed amendments under the AI Liability Directive. Starting first again with a sort of key takeaway, and that's that the proposal will create broad rights of access to company documents and make AI related claims more likely to be subject to class action. How's it going to do that? Well, it's going to require EU countries to give powers to courts to order disclosure of technical information about high-risk AI systems. We'll come on to the risk categorization of AI, but that's a concept that's been borrowed from the second bespoke regime that we'll talk about, the regulatory regime, and where, again, the threshold, similar to under the PLD, revised PLD, is simply establishing a plausible case, a very low bar. Non-compliance, again, like the PLD, with those disclosure obligations can alleviate the burden of proof, reverses the burden.